So let's begin. So the approach that I'm going to take is I'm going to work my way through the PowerPoint. I'm going to stop at various points and ask if there are any questions. The idea of forcing people to listen to a legal academic for an hour without a break clearly constitutes cruel and unusual punishment under the Canadian Charter. My goal is quite simple. I want each and every one of you to come away with a good working understanding of the potential liability of alcohol manufacturers and government liquor authorities for their failure to warn consumers of the risks of fetal alcohol syndrome. Okay. So slide 1, Tina, I don't know if you're putting it up on the screen. Although the estimates vary significantly, it is generally accepted that fetal alcohol syndrome disorder is more common in Canada than all of the other major causes of developmental disabilities combined. In one study, it was indicated that FASD is 2.5 times more common than autism spectrum disorder, 19 times more common than cerebral palsy, 28 times more common than Down syndrome, and 40 times more common than Tourette's syndrome. FASD is a broad diagnostic term that includes at least 3 related conditions, which are commonly listed in order of severity as fetal alcohol syndrome, partial fetal alcohol syndrome, and alcohol-related neurodevelopmental disorder. Now, all 3 diagnoses are associated with cognitive and behavioral deficit, but only fetal alcohol syndrome and partial fetal alcohol syndrome are characterized by facial dysmorphology and growth deficiencies. And that is important from a causation perspective in attempting to prove that the child suffers from FASD as opposed to some other disorder. Now, some researchers divide alcohol-related neurodevelopmental disorder, or ARNT, into ARNT-C, which is cognitive disability, and ARNT-B, which is behavioral disabilities. Other researchers include alcohol-related birth defects within the realm of fetal alcohol syndrome disorders. Now, unlike the role that alcohol plays in various cancers, heart disease, stroke, cirrhosis, FASD results exclusively from alcohol, which facilitates proving causation in any related civil suit. At common law, in order to succeed, the plaintiff must prove on a balance of probability that the defendant's conduct was a cause of their loss. So, for example, if 20% of breast cancer is attributable to alcohol, the plaintiff is not going to be able to prove in any one case that their breast cancer was caused by alcohol as opposed to occurring due to other factors. No such problem arises with FASD. It is exclusively caused by prenatal consumption of alcohol. Now, children with FASD may suffer anything from mild intellectual or behavioral deficits to profound physical disabilities and premature death. The extent of a child's FASD disabilities varies depending on how much alcohol his or her mother drank, when in the pregnancy it was consumed, the frequency of heavy drinking, genetics, and other factors. So quite clearly, FASD is a major public health problem, but the federal government response has been extremely disappointing. Next slide, please. Unlike tobacco and cannabis, alcohol is not subject to any stringent federal advertising, marketing, packaging, or health labeling requirements. Despite accounting for about 18,000 deaths a year and almost $20 billion in public costs, The public costs of alcohol exceed government revenues by about $6.5 billion. Thus, you and I generously are subsidizing the alcohol industry. They appear to make all the money, and we pick up all the pieces. However, that's a different story. Contrary to what the alcohol industry has argued, there are no legal obstacles to enacting comprehensive legislation requiring all alcohol products to include health information and warning labels. So despite what the alcohol industry has argued, the federal, provincial, and territorial governments all have very broad constitutional authority to enact such legislation. The federal government could enact that legislation under its broad criminal law power. The provinces and territories have even broader legal authority to enact the legislation under their constitutional authority over health, over matters of merely local or private nature, and their constitutional authority over property and civil rights. So both levels of government have legal authority to enact the legislation. Contrary to what the alcohol industry has argued, that legislation would not violate the Canadian Charter of Rights and Freedoms. Now, while mandated labeling may infringe Section 2B of the Charter, freedom of speech, the legislation would be upheld under Section 1 of the Charter as a reasonable limit, demonstrably justifiable in a free and democratic society. In regards to the Charter, it's important to understand that the Canadian courts have upheld the federal government's near total ban on tobacco advertising. The Canadian courts have upheld the packaging requirements under federal law, which requires 75% of the packaging of the major display panels on cigarette packages to have these very gory, full-color picture of tobacco diseases. So there's no question that the legislation would be upheld under the Charter. The legislation would not violate international trade law. I'm not an expert in trade law, but when I spoke to my colleague who teaches in this area, he said as long as the labeling legislation applied equally to domestic products and products that were imported, there would be no violation of trade law. Nor would the imposition of these labels give rise to potential civil liability of the provinces for injurious falsehood, sometimes called slander of goods. The alcohol industry, in order to sustain an action against the government, would have to prove that the labeling, the information in the labels was factually untrue. And they would have to prove that the government did this out of malice or spite, not a chance. So there are no legal obstacles to the federal and provincial and territorial governments introducing this legislation. Okay. Unfortunately, particularly the federal government has failed to do so. Next slide. There were 9 private members' bills requiring warning labels on alcohol products introduced in Parliament between 1988 and 2006. The first 8 died on the order paper, and the 9th was defeated overwhelmingly. The most recent private member's bill calling for alcohol warning labels was introduced in November of 2022, and it is unlikely that it will fare any better. In a study of over 1,000 private members' bills between 1994 and the year 2000, less than 2% were enacted. Of those, only half dealt with substantive matters. So the likelihood of private members' legislation resulting in the enactment of federal warning labels is limited. In my view, the threat of being sued and held liable provides another means of encouraging the alcohol industry and government liquor authorities to better inform women and their partners of the risks of FASD. So it's another means of getting the government to move forward. Next slide, please. Now, a prenatal injury case, that's where a fetus is injured and the child is born alive, including those based on FASD, typically generate two sets of claims. One claim brought by the disabled child, brought on behalf of the disabled child for the injuries that he or she suffered in utero. And a second claim brought by the parents of the child for the additional care that they've provided and the additional costs incurred that have been attributable to their child's disability. Both types of these FASD-related claims are viable based on existing common law negligence principles that apply throughout Canada. My talk is going to be limited to common law principles of negligence, and in my view, both types of claims would be successful. Common law does not apply in Quebec. In Quebec, the issue would be governed by the Quebec Civil Code, and liability under the Quebec Civil Code is considerably broader than under the common law. So the prospects of a successful suit against an alcohol manufacturer, liquor authorities for failing to warn of fetal alcohol syndrome disorder in Quebec are even better than in the rest of Canada. Well, I think I'm going to stop at that point, Tina, and see if there are any questions.
Thank you, Robert. No questions at this time, so happy to proceed.
Okay. Don't be shy about asking questions. We can assume that they're from friends of yours who work in agencies far away in a time long ago. All right. Next slide, please. So now what we're going to do is we're going to look at the elements of a common law negligence suit. What does the plaintiff have to prove in order to succeed? All common law negligence actions involve the same 6 basic issues. Whether the claim is brought against an alcohol manufacturer for failing to inform a woman of the risks of FASD, or a careless driver for car crash injuries. First, the plaintiff must establish that the defendant has a legal obligation to exercise care for his or her benefit in the circumstances of the case. So the first issue that the plaintiff must establish on a balance of probability is that they are owed a duty of care. Second issue is the standard of care and its breach. The plaintiff must prove that, based on all the facts of the case, the defendant breached the requisite standard of care. Third, the plaintiff must prove that the defendant's breach of the standard of care was a cause of his or her claimed loss. The two most controversial aspects of a fetal alcohol syndrome disorder claim will be whether the manufacturers breached the standard of care and causation. The fourth element that the plaintiff must prove is that the causal relationship between the plaintiff's injuries and the defendant's negligence are not too remote in law or tenuous to be recoverable. The fifth issue that the plaintiff must prove is that he or she has suffered legally recognized losses and must establish the extent of those losses. Certain losses, such as death or grief, are not per se or in and of themselves recoverable at common law. Now, legislation has been enacted in every jurisdiction, allowing dependents to claim for the economic losses that resulted from the death, but the death itself and grief are not recoverable. And finally, the sixth element in a common law negligence action are the defenses or prejudicial conduct. The defendant must establish that the plaintiff's prejudicial conduct justifies reducing or eliminating the claim. The two most relevant defenses are contributory negligence and voluntary assumption of risk. The plaintiff has the burden of establishing each of the first 5 elements of the cause of action on a balance of probability, and the defendant has the burden of proving any alleged defense to the same standard of proof. Okay, the next slide, please. We're going to go through each one of these elements of the negligence action and apply it to fetal alcohol syndrome and manufacturer's duty to warn. The Supreme Court of Canada has repeatedly held that both manufacturers and also suppliers have a broad common law duty to inform consumers of the risks inherent in using their products. A couple of things to understand. This duty applies to manufacturers and suppliers. Second thing to understand, it's a duty to inform. Providing a warning label is simply one of the mechanisms that can be chosen to inform. And so the duty is simply broader than simply providing a warning. Okay. Now, as the Supreme Court noted in a 1995 case of Hollis, quote, "It cannot be said that requiring manufacturers to be forthright about the risks inherent in the use of their products imposes an onerous burden on them." Now, at one point, if an infant was injured in utero and was born alive, they had no claim. And at that time, the sense was that how could they have a claim if they weren't a legal person at the time? Now, that principle has been rejected in a Quebec case, Montreal Tramways in 1933. So the fact that an infant who is subsequently born alive was injured in utero is no bar to a cause of action brought on his or her behalf against those who caused or contributed to the injuries. But with one important exception. The Supreme Court of Canada, in a case called Dobson in 1999, held that for policy reasons, a pregnant woman does not owe a duty of care to her fetus. Now, this is important because this would prevent manufacturers and suppliers who are held liable to an infant from joining the mother as a co-defendant or seeking contribution from her. In other words, if they were sued and held liable, they couldn't attempt to recover some of that money from the mother. It would also likely preclude them from raising her behavior as a defense. Given the monopoly over the wholesale alcohol market within their boundaries, the provincial and territorial liquor authorities are alcohol suppliers. At the retail level, some of it is privatized, but not at the wholesale level. So in every jurisdiction in Canada, the provincial and territorial liquor authorities are suppliers. They control the wholesale market. Thus, like alcohol manufacturers, they have a duty to inform consumers of the risks of alcohol consumption. Now, consumers don't have to be informed of obvious or well-known risks. You don't have to warn that knives will cut. However, those situations of an obvious or well-known risk has to be distinguished from those in which the consumer has only a vague understanding of the risks or is aware of only some of the risks. Although most women in Canada have heard of FASD and understand they should limit their drinking during pregnancy, many are unaware that their fetus can suffer profound, lifelong alcohol-related injuries before they realize that they are pregnant. As one UK commentator noted, quote, "Current public health advice to abstain from alcohol throughout pregnancy overlooks two important reproductive realities for women. Almost half of the pregnancies in the UK are unplanned. The statistic in Canada is the same. And there's a period of time at the start of pregnancy, on average halfway through the first trimester, that a woman is unaware that she is pregnant." Similarly, many women may not be aware that FASD is the leading preventable cause of birth defects and developmental delays in Canada. Nor are they likely aware that as many as 1 in 25 Canadian children are born with FASD-related impairments of some kind. So what's the bottom line on duty of care? Canadian alcohol manufacturers and suppliers, which includes the provincial and territorial liquor authorities, have a broad common law duty to inform women of the risks that alcohol consumption poses of having an infant born with FASD. Okay, Tina, I'm going to see if there are any questions.
Thanks, Robert. So at this time, we have 2 questions. Neither are specifically about these principles of law that you've touched on. They're a bit more general. Would you like me to pose those to you now or at the end?
You can ask them now.
Okay, perfect. So the first question is, have warning labels on other controlled substances, such as tobacco and cannabis, been effective in changing use behavior or any other labeling goals?
Okay, so this is a matter that alcohol researchers are probably better qualified to answer than me. It is clear that general labels, which are not prominent, which are buried in the product, generally don't have much of an impact. My understanding, and there's people who are better qualified than me to answer, is that prominent labels coupled with graphics prominently displayed do have an impact on not only knowledge, but also on behavior. So I'm not the best person, but my understanding is that good labeling legislation, if accompanied by graphics prominently displayed, does have an impact both on knowledge and on behavior. Next question.
Thank you, Robert. And I'll just add for folks that may not be aware, on the Cape Community of Practice website, there is also a link that we compile, and there is a section of labeling resources in that document that you might like to refer to. The second question is, what are your thoughts about the class action lawsuit that was filed recently in Quebec against the SAQ and some alcohol producers?
I was going to sort of thank you for that question. There are in fact 2 suits, class action suits, as I understand it, that have been brought. As I understand it, the class action suits are for 7 types of cancer that are associated with alcohol consumption. I've read the brief or the statement of claim. I think one of my concerns is it's not clear how the plaintiffs in those cases are going to prove causation, because the 7 types of cancers that they're suing for, the majority of those types of cancers, as I understand it, are not caused by alcohol. So we'll have to wait and see. But it is clear that liability in Quebec is much broader, in my view, than under the common law principles. So, for example, under the Quebec Civil Code, the fact that you have breached a statute is a fault that gives rise to damage. At common law, in the common law jurisdictions, the fact that you have breached the statute does not give rise to liability. And so the prospects in Quebec are better. We'll have to wait and see what the response is in terms of those 2 civil suits. One of the reasons why I focused on fetal alcohol syndrome disorder for this talk, as opposed to some of the other harms caused by alcohol, such as breast cancer, is that with FASD, it is much easier to prove a cause. because FASD is solely attributed to alcohol, whereas with breast cancer, the majority of cases are not attributable to alcohol. Okay, any other questions?
Thank you, Robert. Those are the only questions for now, so we're fine to proceed.
Okay. The next slide, please. So once the plaintiff has established that the alcohol manufacturers owe them and suppliers owe them a duty of care, they have to establish that they breached the standard of care. Okay. Alcohol manufacturing suppliers must disclose the risks posed by both the foreseeable use and also the foreseeable misuse of their products. Inevitably, the alcohol industry will argue that the harms caused by alcohol are unforeseeable, that if you drink moderately, there are no harms. Well, not so fast. Given the high rates of binge drinking among Canadian women of childbearing age, the risk posed by this pattern of consumption, which includes having infants with severe FASD-related disabilities, cannot be written off as unforeseeable and must be disclosed. Although the rates of binge drinking or heavy drinking are lower among women than among men, in 2022, approximately 25% of females aged 18 to 34 and 20% of women aged 35 to 49 were binge or heavy drinkers. Now, what that means is the definition for a woman to be a binge or heavy drinker in this study was consuming at least 4 drinks per occasion, at least once a month, all year. In an earlier study, it was estimated that 37% of babies born in Canada were exposed to multiple episodes of maternal binge drinking. In that study, binge drinking was defined as consuming at least 5 standard drinks per occasion. So because binge drinking is commonplace, it cannot be written off as being unforeseeable, and therefore manufacturers have to provide an appropriate warning in regard to that. Manufacturers and suppliers have to tell the whole story. They can't bury, gloss over, or obscure the risks associated with the product. If the risk is serious, a general or blanket warning will be insufficient. In terms of products that are intended for human consumption, the courts have imposed a very high standard of disclosure. And the disclosure, the standard of disclosure increases with the probability of harm. And notice the fetal alcohol syndrome disorder is the major cause by far of birth defects, and the potential severity of the harm. And so FASD, both in terms of its probability and potential severity, the standard of disclosure is extremely high. The Ontario Court of Appeal, in a case called Ortho in 1986, stated, the information and warning must be sufficiently specific, detailed, and prominent to alert consumers to the nature, probability, and severity of each known risk. The standard of disclosure is higher for products that are intended for the general public, such as alcohol, and for products that are mass marketed to a constituency that includes vulnerable individuals such as youth. Manufacturers and suppliers can't ignore or discount objective medical research just because they don't believe the research to be true or because they believe their products are safe. Now, the fact that information about FASD is available from health agencies and other third parties does not lessen the obligation of alcohol manufacturers and suppliers to directly inform the public. Now, even if a warning is given, it will be assessed in terms of the totality of the defendant's marketing practices, including any countervailing messages or activities. One of the reasons why in the tobacco, duty to warn tobacco cases in Quebec, one of the reasons why the tobacco companies were held liable for punitive damages, in addition to compensatory damages, was because they knowingly made statements that were false. And so the fact that a warning has been given is one factor, and it must be viewed in the context of the totality of the activities of the industry. Now, the fact that a manufacturer supplier has complied with a federal warning label legislation, if such legislation existed, would not preempt or prevent them from being sued for breaching their common law duty to inform. In the United States, if a manufacturer complies with a federal warning legislation or federal labeling legislation, they cannot be sued in the United States. It precludes or preempts civil liability, not in Canada. So even if warning label legislation was enacted or health information labeling was enacted, and the alcohol industry complied with it, and that would not protect them from civil liability. As the courts have said, complying with a federal or provincial or territorial labeling legislation is only relevant if the statutory requirements are coextensive with the common law duty to inform consumers. So the alcohol industry, if it were to argue that it complies with current federal labeling and packaging legislation, wouldn't provide immunity from suit. The fact that an alcohol manufacturer complied with a provincial labeling legislation, as exists in some of the territories, would not protect them from potential civil liability. So what's the bottom line on the standard of care? Canadian alcohol manufacturers and government legal authorities have breached the standard of care by failing to clearly inform women of, among other things, the prevalence of FASD, its potentially lifelong catastrophic impact on children, and that the risk that their fetus may suffer profound alcohol-related injuries before they realize that they are pregnant. In my view, it's quite clear there is a duty of care on manufacturers and suppliers, and it is quite clear, at least in my view, that they have breached the standard of care. Any questions, Tina?
Thank you, Robert. Yes, we have two questions in the chat that are somewhat related. It links back to the question around the direct link. So the first question is, could you clarify your position about the direct link between alcohol and several types of cancer, considering what the World Health Organization is reporting? The related question for context is, in the tobacco litigations, the cancers and other health problems invoked were not solely attributable to tobacco. So for example, a pulmonary cancer could be caused by air pollutants.
Okay. At common law, you have to prove on the balance of probability that the defendant's conduct was a cause. Now, if legislation is enacted to allow proportional accountability or liability, then there's no problem. So in every jurisdiction in Canada, the provincial governments enacted tobacco cost recovery legislation, which allowed for proportionate recovery. So if tobacco was responsible for 25% of, let's say, bowel cancer, the industry was made liable for 25% of the total number of bowel cancers. But that was done by legislation. In Canada, there is no legislation in the common law jurisdictions allowing for proportional recovery. And so that's why I chose FASD, because that's not a problem with FASD. It is caused exclusively by alcohol consumption. Whereas with some of the other alcohol-related harms, the many alcohol-related harms, alcohol may be accountable for 20%, 25%. But if that percentage is below 50%, they will lose on causation. So how it was possible with tobacco was because of legislation changing the common law, permitting proportional recovery based on its causal role.
Thank you, Robert. We have a couple of more.
I hope that answered that question. I think.
Fabulous, thank you. We have a couple of more questions coming into the chat now. One is, does addiction to a substance have any bearing on the consumer's conduct?
Yes. Okay. So does addiction have an impact? If you become addicted to a substance such as tobacco, at that point forward, you may not be held to have been contributory negligent for failing to stop because you've been addicted. So in the tobacco class action suits in Quebec, the fact that many of the people were addicted to tobacco before there was any warning permitted them to continue or to succeed. Whereas if there was an adequate warning given and you began to smoke, then the tobacco industry could not be held accountable. So yes, addiction plays a role.
Thank you, Robert. We have another question that links back to some of the content you were mentioning about the duty to warn, particularly for governments. The question is, what about public education campaigns that provincial governments have undertaken to warn people about risk of drinking while pregnant? Could they argue they have attempted to warn people about the risks of FASD?
Okay. As a general rule, the principle is that the industry can't rely on third parties. In other words, the fact that the information is available from other sources doesn't lessen their obligation. Now, I think that we're going to have to wait and see how the courts respond to the argument, let's say by a liquor authority, saying it doesn't make sense for us to try to inform members of the general public on the bottle, etc. It makes a lot more sense for us to coordinate our information packages with the provincial health or territorial health authorities. This is one of the additional areas that I want to explore. So I think if the government had a comprehensive plan to inform the public, and part of it was in terms of labeling and signage, and part of it was through public health promotion, then I think the courts would have to attempt to balance. Now, if the public health messages are sufficiently detailed, prominent, etc., in terms of the probability severity of the risks of FASD may be viewed by the courts as being obvious or sufficiently well known. So a government health information program about FASD may have the potential of convincing a court that the risks of FASD are sufficiently well-known or obvious such that the manufacturer does not have to warn of them. But I don't think we're there yet, because when I briefly reviewed the programs, information programs in some of the jurisdictions, there was information on websites about FASD, but the general public wasn't directly and clearly warned, for example, that guess what? You can have your child may be profoundly disabled before you realize that you are pregnant. And nor am I aware that the public has been directly or clearly informed that as many as 1 in 25 children are born with some form of FASD-related disabilities. So I think those programs are important. I think they may have the potential to make FASD a known or obvious risk, but I don't think we're there yet. So we'll have to wait and see how the courts respond.
Thank you, Robert. We have about 3 more questions in the chat that are somewhat more general. Would you like to keep going with questions or move forward in the presentation? What would you prefer?
How about if I do one of those and then move on?
Absolutely, fabulous. So the next question is, given the fact that we know now it does not take copious amounts of alcohol to cause FASD, how many cases of FASD do you think are going undiagnosed or misdiagnosed?
Okay, and again, the people who are researchers in this area are better qualified for me than me to talk about this. But it is quite clear that it's going to be a lot easier to succeed in terms of children with FAS and partial FAS than aren't. The difficulty is that there are way more young children born suffering aren't than FAS or partial FAS. And as I understand it, large numbers of those children born with aren't diagnosed. And so we're unlikely to see as many successful suits in terms of children who are suffering from aren't. The most likely cases that are going to be successful are children who have, facial dysmorphology and growth delays, because it's easier to prove that alcohol is the cause. And I've read some of the literature on the overlap between autism and children with aren't, particularly around the behavioral aspects. So yeah, the first cases that are going to be successful are going to be the children who have the most significant disabilities. Okay, I think I better go on to the next slide, and that deals with causations. The plaintiff must prove on the balance of probability that the defendant's negligent failure to inform was a cause of her claimed losses, and this gets complicated. So I have to prove that the defendant's negligent conduct, that is the failure to warn, was a cause of the claimed loss. And this involves 3 sub-issues. First, the plaintiff must establish that alcohol was the cause of the losses. Once a child has been diagnosed as suffering from FASD, alcohol will be held to be the cause of the disabilities attributable to that diagnosis. Children with the most profound disabilities, namely FAS and partial FAS, are the easiest to diagnose. Children suffering from aren't are harder to diagnose, and many are not identified as having FASD. These challenges, coupled with the fact that there'll be more limited range of potential damages, will result in fewer suits brought on behalf of this larger group of children. So I have to prove that the alcohol was the cause of the harm. Easy with FAS, easy with PFAS, can be much more challenging for children who are suffering from more mild disabilities. Second, the plaintiff must establish that she would have abstained from alcohol or reduced her consumption had she been adequately informed. Now, the Supreme Court of Canada has adopted what has been described variously as a robust, pragmatic, or common sense approach to proof, which permits an inference of causation to be drawn in the plaintiff's favor in the absence of evidence to the contrary. So you've got to prove that alcohol was the cause, and that had I been adequately warned, I would have changed my behavior. And the courts have adopted a somewhat pro-plaintiff approach. In the cases that have been litigated to date, the courts have tended to accept at face value a woman's testimony about the personal choices that she would have made, even if most other women would have made a different decision. Essentially, given the court's approach to causation, refuting a woman's testimony that she would have abstained from or reduced her alcohol consumption if adequately informed will be difficult, unless there's evidence that she knowingly engaged in other high-risk behaviors that were equally threatening to the fetus. In other words, the courts are likely to accept at face value when a woman said, had I known of these risks, I would have stopped drinking. It was only for a 9-month period. And if that's all I had to do to have a healthy kid, etc. So it's going to be difficult for the industry to counter that argument. So you have to prove that alcohol caused the harm. You've got to prove that had you been informed, you would have changed your behavior. And you've got to prove that that change in your behavior would have avoided the harm. So third, the plaintiff must establish that abstaining from or reducing her drinking would have prevented her child from being born with FASD. Now, if the court accepts that the woman would have abstained from drinking, then clearly her infant would not have been born with FASD. More complex causation and evidentiary issues arise if the court finds that the plaintiff would not have abstained from drinking, but would have only moderated her consumption. As noted, there's no simple formula for determining the exact impact of a particular pattern of prenatal drinking. And so some of the cases are going to become very, very complex, where the evidence indicates that the woman would have changed how much she would have drank, but she would have continued drinking modest amounts. And those cases are going to be quite complicated. Now, both the alcohol manufacturer and the government liquor authority may be sued for failing to warn. But fewer causation issues arise in suing the government. If I'm suing a manufacturer, I have to prove that it was the manufacturer's product as opposed to alcohol from other sources that caused the claimed losses. A woman may have no recollection who manufactured the beer that she was drinking in the early stages of her pregnancy. She may have no recollection of that, or she may have consumed alcohol from a number of different sources. No such problem arises in suing the provincial and territorial liquor authorities, because they're the suppliers of virtually all the alcohol that is sold and consumed within their borders. So the government liquor authorities are easier to sue and hold to account than the alcohol manufacturers. Now, this is in the common law jurisdictions. This is particularly the case. What's the bottom line on causation? Children born with FAS or partial FAS and their parents should have relatively little difficulty establishing causation, particularly in suing government liquor authorities. Proving causation will be more challenging in the case of children born with ARNT. Okay, I think I'm going to go on to talk about remoteness, which is not particularly controversial, and then I'll open the floor for questions. So the general test of remoteness, remember, the plaintiff must prove that their injuries are not too remote in law from the defendant's negligence. So the general test of remoteness is framed in terms of whether the plaintiff's losses are a foreseeable result of the defendant's negligence. Now, the general test of remoteness has been broadened by the adoption of two principles. The first is the kind of injury test, and the second is the thin skull plaintiff test. Once the kind of injury the plaintiff suffered is foreseeable, in this case, FASD disabilities and additional child rearing care and costs, all such injuries, care, and costs are recoverable, even if they far exceeded what was anticipated. So if a woman consumed moderate amounts of alcohol, modest amounts of alcohol, let us say, and yet her child was severely disabled, which is uncharacteristic given her pattern of consumption, it doesn't matter. Once FASD disabilities of any kind were foreseeable, then all of those losses can be recovered, even if the extent of those losses far exceeded what was anticipated. Pursuant to the thin skull plaintiff rule, once the kind of injury the plaintiff suffered is foreseeable, the defendant is held liable for any unforeseeable consequences that resulted from the plaintiff's pre-existing susceptibility. So, for example, an alcohol manufacturer wouldn't be relieved of liability simply because a woman's unique genetic makeup or age greatly increased the risk of having a child with FASD. Bottom line on remoteness, the infant's FASD-related injuries and his or her parents' additional child rearing costs and care are a foreseeable result of the defendant's failure to adequately disclose the risk. Consequently, these losses are not too remote in law and will be recoverable. So remoteness of damage is not going to pose much of a burden or obstacle to a successful suit. I'm going to open the floor for questions at this point. Tina?
Hi, Robert. So we still have those 3 questions that were pre-existing. Would you like me to pose any of those or hold them till the end?
Sure. Why don't we
Let's pick one out of the hat.
Yeah.
All right. So this one I'm happy to repeat a second time if necessary. This is amazing information that can help so many, as well as furthering the push for improving protection. Considering parents, guardians of children with disabilities are often extremely busy, and people living with FASD may not have the capacity to advocate for themselves. Is there an effort for this information to get to the key interested parties? And how about legal supports for people to qualify and sue?
Okay. As I said, I gave my first talk in 1992 on this issue. And so we haven't made much progress since. I'd like to believe that governments and our political masters are concerned with doing what's right. Unfortunately, this is clearly not the case in regard to this issue. So the threat of civil suit, the fact that the government can be sued and held liable, should, I think, encourage them to better inform. And so I think getting this message out and trying to encourage a law firm to take on this issue is going to be very, very important in getting the changes that we want. Now, I have contacted one of the leading litigation firms to discuss the possibility of moving this issue forward. So I think that's going to be important to see what the response is. And one of the other things, I don't think any individual case is going to go forward. The costs of litigating these cases are so great that it's going to have to be a class action suit. And you're going to have a law firm that's willing to take the risk of investing a huge amount of resources in what will be a protracted legal proceeding in order for them to take this issue on. That's why I think the first claims are going to be for FAS and PFAS, because the damages are higher and because the issues of proof are easier. Next question.
Thank you, Robert. The next question relates to the Private Members Bill. Given that only 2% are successful, can you comment on factors that enable a successful outcome? So, for example, are there actions that health organizations can undertake to support the current Private Members Bill that is calling for warning labels currently?
Yeah. Now, sometimes if there is a huge groundswell of public support, a government will take over a private member's bill and introduce it as a government bill. So everything that is being done to increase the visibility of this private member's bill and the rationale for it and the benefits of warning label legislation is positive, because it will increase the likelihood that a government will take on this issue. And there's another issue. You know, I was asked about warning labels and whether or not they have effect. Whether or not a warning label changes behavior, I strongly believe that consumers have a right to know. And it can be justified, requiring the manufacturers to provide labels and warnings can be justified on that basis alone. Consumers have a right to know. And I think that it's really, really important. So anything we can do to encourage and increase the visibility of the private members bill, to convince our political masters that there is support for this legislation, makes it more likely that the government will do the right thing. Next question.
Thank you, Robert. The third question is, other than the recent Quebec cases, why do you think other cases have not been brought against manufacturers or suppliers of alcohol to date?
Okay, a couple of reasons. We've made excuses for alcohol for years and years, and you know, we've always given alcohol a pass. We've never held them to account. Now, as the research indicates that the extent of the harm and cost it's imposing, there are both political barriers to holding them to account and financial barriers to holding them to account. I mean, basically, what you're doing is you're suing a multi-billion-dollar industry. Look at the tobacco litigation. It's taken, what, 15, 20 years in terms of the tobacco cost recovery legislation? And what did the tobacco industry did? What I knew they inevitably were going to do. They probably transferred all their assets and declared bankruptcy. And so there are major challenges in this area. And, you know, I mean, you look around in terms of recent government alcohol policy, there appears to be political reasons to increasingly deregulate alcohol. The Premier Ford has recently indicated he's going to put alcohol in corner stores. I guess, you know, one of the things I in my more cynical moments think that, you know, if $1 million flows through the front door in taxes and $2 million flow out the back door in public costs, you're not really ahead. And so the politics and costs are the major obstacles to, one, the government introducing legislation, and two, law firms taking these issues on. But one of the things about fetal alcohol syndrome is the victim is completely innocent. You have a child who's permanently disabled. The child's never done anything. The child's never engaged in any wrongful or irresponsible behavior. And so that's why I think this claim, this kind of alcohol-related claim, are likely to be the first claims that are going to be made and the first claims that are going to be successful. Next question. Oh,
thank you, Robert. That's all the questions we have at this time, so we can move forward.
Oh, good. Thank you. All right. Next slide. Actual loss or damage. So the general principles for assessing compensatory damages are easy to state. The purpose of a damage award is to put the plaintiff in the position they would have been in to the extent that money can do so had the wrong not been committed. So the principle is easy to state but hard to apply. So applying this principle to children with significant disabilities involves very complex evidentiary calculations and assumptions about the child's life expectancy. In one of the prenatal injury cases, at the time of trial, the child was 7, and the court calculated that they were going to need virtually continuous care for the next 55 years. And so the actual calculation of damages is probably going to have to require, well, probably will require expert testimony. These cases typically generate million-dollar damage awards and take years to resolve. In one of the cases, it's a case called Crawford, there was a negligence in labor and delivery. The case took 20 years to finally resolve, and the damage award was $10 million. So damage calculations are complex and require expert evidence. Now, the claims by parents to recover their additional care that they provided because of the disability and additional costs are generally less complex, and the damage awards are lower. Children born with FASD and their parents suffer a broad range of losses that are recoverable. So the calculations may be complex, but there will be little difficulty establishing the plaintiff proving actual loss. All right, the last issue is prejudicial conduct. If the defendant can establish a defense, that will reduce or in some cases negate the claim. Now, if the tobacco litigation is any indication, the alcohol manufacturers will raise numerous defenses. Nevertheless, it's fanciful to suggest that the conduct of the disabled child provides any grounds for asserting any recognized defense to civil liability. So in terms of a disabled child's claim, there are no defenses that can be raised against the claim made on behalf of a disabled child. However, in terms of the parental claim for additional child rearing care and costs, the industry will likely raise two defenses: the defense of contributory negligence and voluntary assumption of risk. Now, remember, the Supreme Court of Canada held that women do not owe a duty of care to her fetus. So if she doesn't owe a duty of care, she can't be held liable. So this would likely preclude raising her conduct as a defense to a parental claim. In any event, establishing contributory negligence or voluntary assumption of risk would be extremely difficult in an FASD case. So in order to establish, even if the courts, and this would be contrary to the general nature of the Supreme Court's decision in Dobson, even if the woman's behavior could be raised as a defense to a parental claim, it's unlikely to succeed on its merits. In order to establish contributory negligence, a defendant must prove that the woman breached the standard of care expected of a reasonable person in her position, and that this breach was a cause of her loss. But remember, what is the parental claim based on? Once a court accepts that the defendant failed to adequately inform the plaintiff of the risks of FASD, it would be difficult to assert that she was negligent regarding risks of which she was not informed. Similarly, the defense of voluntary assumption of risk, you have to prove that the plaintiff was fully aware of the probability, severity, and nature of the risk and agreed to waive her right to sue. the essence of the parental claim is that they were unaware of the risks. So it is, in my view, unlikely that the defendants will be able to successfully raise a defense. Now, another issue that should be that I want to raise in this regard: if a woman decided to sue only the alcohol manufacturers, the manufacturers would inevitably drag the government into the litigation, either by making a third-party claim against the government liquor authority or by seeking contribution or identity from the government liquor authority. Now, note that a pregnant woman does not owe a duty of care to her fetus, and any attempt to make a third-party claim against her or obtain contribution or indemnity from her would fail. So, defendants sued for failing to disclose the risks of FASD will not be able to establish a defense of contributory negligence or voluntary assumption of risk. Clearly not against the infant, but also against the aparental claim. All right, any questions?
No further questions at this time, Robert.
Okay. Now, I should again reiterate, if individuals wish more information on any of those issues, I put my phone number and my email address on the outline on the PowerPoint. I do better on the phone than I do by email. So if you email me, please include a phone number at which you can be reached, because chances are I will return your call as opposed to type a response. All right, so let's conclude. Alcohol manufacturers and government liquor authorities have fallen, in my view, far short of their obligation to disclose the risks of FASD, which is by far the leading cause of birth defects, cognitive impairment, and physical disabilities among Canadian infants. Now, the legal principles in terms of the duty to inform were established 40 years ago. And they provide parents and children with a viable basis of suing alcohol manufacturers and government liquor authorities for FASD-related losses. In my view, the major barrier to such claims is not the governing legal principles, but rather the challenges that even knowledgeable plaintiffs face in suing multi-billion-dollar defendants. Now, the lack of successful FASD-related civil suits to date is reminiscent of the situation with the tobacco industry. We knew in the early 60s that tobacco had devastating health impact, and yet it evaded liability for decades. It appears that the Canadian alcohol industry is on a similar trajectory. In my view, it's only a matter of time before Canadian alcohol manufacturers and government liquor authorities are sued and held liable for failing to warn of the risks of FASD. Thank you.